Thank you, colleagues. Being the last on the list, I risk being repetitive, but I'll do my best to move through. I rise today as a member of SOCI to relay witness concerns on Bill C-12, and specifically on this amendment, which stands out to me as fundamental. And thank you to Senator Simons and Wu for sharing results of the earlier pilot you mentioned. I was unaware of that work, but it has further convinced me to support this amendment. Hearing from witnesses at SOCI, I was struck by how many expressed deep concerns for the people who will ultimately have to navigate the system under C-12. We have reviewed the lived reality of some of those who will interact with the refugee claim system. And we have heard a lot of the stories around survivors of torture, many coming from countries of war, fleeing gender-based violence. I won't go through that again because I think we understand the seriousness. But what I will say is that these people are not arriving as fully prepared litigants. As Amnesty International told us, they often mistrust authorities and are deeply frightened. Psychologists will tell us that these realities take time and courage to address, and how much time is different for everyone. But the timeline, as we've talked about earlier, outlined in C-12 is the same, 12 months. Regardless of circumstances, I want to relay what we heard from many witnesses on this topic. Making a claim in a timely manner is irrelevant to whether a person needs protection. I'll quote the Canadian Council for Refugees. How or when a person arrived has no bearing on their need for protection. And this raises a broader question about the policy choices being made in Bill C-12. In my view, this provision sets aside individual circumstances and instead relies on a fixed timeline to decide who can access Canada's refugee determination system. At SOCI, we heard examples of how rigid timelines can produce deeply unfair outcomes. And what happens when someone misses the one-year deadline? C-12 would prevent them from having their claim heard before Immigration Refugee Board. Instead, they are diverted to a pre-removal risk assessment process, commonly referred to as PRA, housed inside IRCC, a department that recently experienced significant budget cuts similar to all federal departments. Witnesses were remarkably consistent in their concerns about this substitution. The Canadian Association of Refugee Lawyers warned that the bill would shift new ineligible claims away from the Immigration Refugee Board of Canada to a deficient paper-based process with no right to a hearing. The David Asper Centre for Constitutional Rights went further, warning in their submission that moving to written submissions in the PRA breaches the fair hearing aspect of the principles of fundamental justice. And the CBA, Canadian Bar Association, said that constitutional compliance cannot be guaranteed given the fact that there is not an embedded right to an oral hearing in the PRA process. These concerns are not new in Canadian law. We heard the Supreme Court of Canada in the Singh decision establish that refugee claimants are entitled to a fair hearing when decisions affecting their life and security are being made. Several witnesses expressed concern that the legislation could result in fewer safeguards against getting it wrong for individuals who have come to Canada as a last hope. These decisions can carry life and death consequences for those seeking refuge. I asked the chairperson of the IRB whether they were concerned about the move toward the PRA process. She explained that right now the IRB gives full oral hearings and issues extensive reasons for the decisions they make. Under C-12, a fairly significant portion of cases will be put in front of PRA without the benefit of that information. And she said whether that creates a charter challenge will likely be argued in court, so we'll find out. While I'm concerned about constitutionality, the government has insisted the bill is constitutionally sound. I have a far simpler policy question I want to get on the record. Why are we diverting cases away from the IRB? Some have suggested that these measures are necessary because the IRB wait times are too long. But diverting claims away from the board does not solve the underlying problem. It simply shifts the burden elsewhere. The committee heard that there will be additional PRA officers hired and they will be well trained. As a former mental health therapist, I am trying to figure out what training they will receive that could possibly replace face-to-face interventions where emotional reactions can be far better assessed and accounted for. The committee was unable to get information related to hiring additional IRB officers to deal with backlog versus hiring additional PRA officers. So it is unknown whether this proposed system will be more efficient or accurate in its decision. The committee also heard that judicial review of PRA decisions would likely increase the backlogs at the federal court. In other words, cases may simply reappear later in the system in a different form. Several stakeholders argued that a more effective approach would be to strengthen the system we already have. The Bellissimo Law Group recommended expanding the IRB's adjudicative capacity so that it can address backlogs without sacrificing fairness. Canada already has a credible refugee determination system. The challenge is ensuring it has the resources necessary to do its work. But colleagues, as a senator, I believe it is beyond the scope of work to amend the legislation before us simply because I may disagree with the policy intent. This is a disagreement that reasonable folks can have, and I will defer to the elected House on that matter, having put my concerns on the record. However, the amendment before us addresses something different from a policy disagreement. The amendment Senator Wu is proposing addresses the fair treatment of minority groups in Canada and the charter compliance of this legislation. It does this by guaranteeing an oral hearing for those folks that end up in the new ineligibility streams created by C-12. This amendment responds directly to concerns about the constitutionality of this legislation raised by the CBA, Canadian Bar Association, the Canadian Association of Refugee Lawyers, the David Asper Centre for Constitutional Rights at U of T, Canadian Muslim Lawyers Association, frontline clinics like Community Legal Services of Ottawa. It aligns this bill with Canadian jurisprudence, and it responds to concerns we heard clearly from the UNHRC, who said that the oral hearing requirement must be added to the legislation to ensure Canada is respecting its international obligations and that asylum seekers have a right to be heard. I support Senator Wu's amendment because it addresses both of those concerns. It is, in my view, a targeted amendment focused on issues that are central to our role as senators. Furthermore, as you've already heard tonight, my understanding is that it aligns with a similar amendment that, again, as we've heard, Liberal MPs made to their government's bill for the very same reasons in 2019, when similar ineligibility provisions were introduced in Bill C-97. Put another way, I'm adding a little water to my wine tonight, and I'm doing my best to respond to voices in my region. I heard directly from the chair of the Saskatchewan Association of Immigrant Settlement and Integration Agencies, Ali Abukar. He asked that we restore access to independent hearings by ensuring that all asylum seekers, regardless of their mode or timing of entry, have right to a full oral hearing before the Immigration and Refugee Board. While I am ultimately accepting the government's policy decision to move away from the IRB process, I will support this amendment that requires IRCC officials to conduct an oral hearing to make an assessment by looking people in the eyes, as it is a targeted improvement to protect minorities and secure charter rights. I want to leave you with the words of Harjit Kaur, Executive Director, Vancouver and Lower Mainland Multicultural Family Support Services Society. The bill is framed as a measure to curb fraud and protect the integrity of the immigration system. However, when these measures disproportionately and severely impact those who are most vulnerable, it is difficult to see how the integrity of the system is being strengthened. Protecting system integrity and protecting victims should not be mutually exclusive goals. Thank you. Merci. Megwich. Merci.